I'm fine, and you?
Me too. And you, Carolina, are you good?
I'm fine, thank you.
Great. So, girls, I'm calling you because I don't know if you noticed, but we have a problem related with this huge rule of law crisis in our beloved Dreamland. Have you heard about it?
Oh, don't tell me. Another breach on the right to a fair trial case. If
Yeah, I know.
Montesquieu was alive, he would have gone absolutely crazy about what's happening in this country.
You are right, Mariana. Talking about separation of powers in Dreamland is just a bad joke.
Yeah, I know. So, do you remember that civil dispute between Mr. X and his neighbor, Mr. Y, the member of the parliament?
Oh, I do. That case reminds me of an old story about a humble miller when he learned that the Prussian king Frederick II the Great ordered the demolition of his mill because it was obstructing the views of the new royal palace in Potsdam. The judge, however, ruled in favor of the miller, commanding the king to rebuild the windmill and to pay appropriate compensation. Then the miller shouted, "There are still judges in Berlin!"
Well, I can't help but wonder, are there still judges in Dreamland?
Yes, that's the point, since in our case, the judge was influenced and decided in favor of his friend, Mr. Y, who, by the way, is a member of the parliament and chairman of the association the judge is a member of.
Exactly. So how can we help Mr. X?
Well, I think the first issue about this case is the increase of the influence of the executive and legislative powers over the justice system of Dreamland.
I agree. The right to a fair trial is foreseen in Article 6, Paragraph 1 of the Convention for the Protection of Human Rights, and it establishes that a case shall be heard by an independent and impartial tribunal.
It's true, and the same right is guaranteed under Article 47 of the Charter of Fundamental Rights of the European Union. And we can't forget that the Charter is part of primary European Union law since the entry into force of the Treaty of Lisbon, assuring the rights and freedoms of any European Union citizen. Isn't that right?
Yes, Carolina, that's absolutely right. Under European Union law, namely on Articles 4, Paragraph 3 and 19 of the Treaty on European Union, member states are legally bound to establish systems of legal remedies and procedures to ensure respect for the right to effective judicial protection guaranteed by European Union law.
That's all right and well, but are you sure that Article 47 wouldn't be compromised by national legal provisions or judicial practices that even weaken the effectiveness of the European Union? Did you look at the factor time limited and others case? I say this because the only way I see Article 47 being effective is if the position of the parties and the circumstances are considered in order to determine whether there was a lack of effective protection. Don't you agree with me? I think I saw this written in the Handbook of European Law regarding access to justice.
Oh, yes, I read it too. In fact, in determining whether a body is able to provide an effective remedy, the facts of the case, the nature of the right at issue, and the powers and guarantees of the body must be considered. This is what European Court of Human Rights case Kudla versus Poland is about.
Yes, Carolina, that's absolutely right. And let me introduce one more crucial aspect in this matter. Article 52, paragraph 3 of the Charter establishes the following. Insofar as the Charter contains rights which correspond to rights guaranteed by the Convention, the meaning and scope of those rights shall be the same as those laid down by the said Convention.
Oh, I see. So we have to bear in mind both Strasbourg and Luxembourg case law to prepare a proper defense for Mr. X.
Good point. European Court of Human Rights, for instance, has consistently stressed that the scope of the state's obligation to ensure a trial by an independent and impartial tribunal under Article 6, paragraph 1 of the Convention is not limited to the judiciary. It also implies obligation on the executive, the legislative, and any other state authority to respect and abide by the judgments and decisions of the courts.
Yeah, and so does the Court of Justice. See the recent case law in Poland's judicial reforms, like joint case C58518 and others. I will send it to you, don't worry. But the thing is, it is important to notice that the Court of Justice has previously held that although the organization of justice in the member states falls within the competence of those member states, the fact remains that when exercising that competence, the member states are required to comply with their obligations deriving from European Union law.
Yes, indeed. It is also set on the Court of Justice case 690 from 2018. Plus, as the European Court of Human Rights has repeatedly held, the concepts of independence and objective impartiality are closely linked, which generally means that they require joint examination. We can see, for instance, Klein and others against the Netherlands.
Besides, in Ramos Nunes de Carvalho e Sá versus Portugal, the European Court of Human Rights stressed that, according to settled case law of such court, in order to establish whether a tribunal is independent within the meaning of Article 6, paragraph 1 of the Convention, it is necessary to analyze the mode of appointment of its members, their term of office, and the existence of guarantees against outside pressures. It is also important to understand if the body at issue presents an appearance of independence.
Yes, that's right. And as regards the condition of impartiality within the meaning of Article 6, paragraph 1 of the Convention, and according also to equally settled case law of the European Court of Human Rights, impartiality can be tested in various ways, namely through a subjective test that must regard the personal convictions and behavior of a particular judge. In other words, it is necessary to examine if the judge gave any indication of personal prejudice or bias in a given case.
Yes, and it is also necessary to do an objective test. This means ascertain whether the tribunal itself offers sufficient guarantees to exclude any legitimate doubt in respect of its impartiality. It is also necessary to determine if there are any facts that may raise doubts the judge's impartiality.
And in that connection, even appearance may be of a certain importance, I guess. Once again, what is at stake is the confidence which the court and democratic society must inspire in the public, and first and foremost in the parties to the proceedings.
Yeah. And regarding our case, don't forget, after all, Judge D is a member of Pro-EU, a well-known association which has a clear and close link to the government, even though I think judges may engage in activities outside their official functions, like that association Pro-EU.
Okay, I think that too, but to avoid actual or perceived conflicts of interest, their participation should be restricted to activities compatible with their impartiality and independence.
No doubt about that. I'm sure that kind of participation of Judge D in Dreamland can't be compared to the case of Judge King, for instance, being a member of the Judicial Association Lex on Republic of X. Do you remember that case?
Yes, I do. And I do agree with you. What happened in the Republic of X can't be compared with what's happening in Dreamland, because in our case, there's no public interest for the judge to be part of the association Pro-EU. After all, it is just some kind of law office preparing legal analysis, opinions, draft laws, and so on for the government. It's obvious that a judge cannot be a part of such organization, don't you think?
Yes, exactly. And on the other hand, Mr. Y is the chairperson of a pro-use branch. Conveniently, Judge D is a part of such branch as well.
Oh my God.
Oh, I see. Like the Roman proverbs say, Caesar's wife must not only be on it, but must also be seen to be honest.
Exactly. In conclusion, we may say that Mr. X's appeal case, Judge D did not comply with his duty of impartiality and was not even able to provide an appearance of such impartiality to the public.
Yeah, and we can also conclude the decision set forth by the Court of Appeal shall not be considered a decision made by the tribunal, because as stressed by the Court of Justice and the European Court case law, for a tribunal to be considered as it It shall be independent and impartial without being subject to hierarchical constraints, orders, or instructions, and absolutely free from any external pressures.
And it clear did not happen in this case. Plus,
Yeah.
do not forget that Judge D was appointed to the Court of Appeal by the High Council of Justice. And according to the new legal regime, members of High Council of Justice are elected by the Parliament against the Constitution of Dreamland.
Yeah.
Yes, and the 2010 recommendation of the Committee of Ministers of the Council of Europe recommends that where a council for the judiciary has been established, not less than half of the members should be judges chosen by their peers from all levels of the judiciary and with respect for pluralism inside the judiciary.
Yes, and the composition of the body which appoints judge is relevant from the standpoint of the requirement of independence. In the opinion of the Venice Commission, do you know, national judge should not be prevented from examining these aspects of the case along with the other elements which may affect the independence and impartiality requirements under Article 6, paragraph 1 of the European Convention.
Yeah, that's true. And I would also like to draw your attention to this point. That is certainly true when the normal chain of appeals is concerned. However, the Strasbourg court did not have the occasion to examine situations when one national court contests the legitimacy of another judicial body, with a reference to the lack of independence or otherwise, outside of the normal chain of appeals, and what should be a proper procedural framework for resolving such disputes.
Yes, and I would now like to move on to the next part. What about the composition of the Court of Appeal? It is formed by one single judge. In addition, the decision of the second instance is final. It is not appealable.
Yeah, I know. In Court of Justice case C6910, this court stated that the principle of effective judicial protection did not require access to a number of levels of jurisdiction. However, in Zubac versus Croatia case, European Court said that Article 6, paragraph 1 secures to everyone the right to have a claim relating to his civil rights and obligations brought before a court. The problem is that in the case of Mr. X, and as we already said, the Court of Appeal cannot be considered as a tribunal since there was no impartiality and independence of Judge D.
That's exactly the point. I have no objection on the fact the appeal court is composed by a single judge and there are no possibility to appeal to a cassation court. However, the court has to be independent and the judge must be impartial.
Yeah, that's right. So now let's change the subject. What about the lack of legal reasoning? According to the Council of Europe recommendation of 2010-12, judges should give clear reasons for their judgments.
Yes, that's obvious. The right to a reasoned decision is a core aspect of the right to a fair hearing. A reasoned decision is essential to demonstrate that a case has been heard properly and permit the parties to bring an appropriate and effective appeal. This is what was decided on the European Court of Human Rights, in the case Jotko against Lithuania.
Yes, I absolutely agree with you, Mariana. In Swaminen versus Fallon, the European Court also stated that in civil proceedings, courts are obliged to give sufficient reasons for their decisions in order to allow individuals to make effective applications for appeal. In principle, it is acceptable for an appellate body to simply endorse the reasons for the lower body's decision. However, this was found to be insufficient when the main complaint in the actual appeal was the inadequacy of the lower court reasoning. The reasons given by the appellate court must address the essence of the issue to be decided in a manner that adequately reflects its role, like in the European Court case Hansen versus Norway.
Yeah, that's true. Have you heard about the case of Age versus Belgium? It's just like this Mr. X versus Dreamland situation.
Oh, yes, I've heard. I think it was about a lawyer, right?
Exactly. He had been disbarred and wanted his restoration to the role. The problem was he had to argue exceptional circumstances, and neither the applicable provisions nor the previous decision of the councils of the bar gave any instruction on what could be exceptional circumstances.
Yeah, right. And the decisions of the Council of the Bar merely noted that there were no such circumstances without explaining why the hell the circumstances relied on by the applicant were not to be regarded as exceptional. So he really didn't know.
Yes, so what happened, it wasn't a lack of legal reasoning. It was no legal reasoning at all. And D followed the exact same unfortunate technique as the bar did on H against Belgium case.
Yes, and Judge D should have provided a proper legal reasoning so that people would understand his way of thinking.
Yes, that's a very good point, Carolina. And we can't forget that in this particular case of Mr. X, there's a fundamental right at stake. The right to property is protected by Article 1 of Protocol number 1 of the Convention.
And also by Article 17 of the Charter.
Yeah.
Then I suppose that the proper reasoning is imposed even more strongly.
Yes, of course. And I would also like to call you for another matter. We cannot forget that Mr. X did not raise any question regarding the composition of the appeal formation. Do you think Article 35 of the European Convention, which states that individuals have to show that they have exhausted all domestic remedies before the European Court considers their case, would be a problem for Mr. X?
That article reflects the principle of subsidiarity, which means that national courts are primarily responsible for guaranteeing and protecting human rights at the national level. See, for example, Scordino versus Italy case.
Yeah, but did he even had a chance to expose the lack of impartiality of Judge D before a national court? Because I really don't think so.
Yes, exactly. I think that's a very good question for us to think about it until next Tuesday. I don't know. Do you think? Do you agree with me?
Yes, I really do agree. It's a great question for us to think about.
Okay, so shall we say goodbye and meet later?
Yeah. Bye. See you.
Okay.
Bye. Bye.
Bye.
Bye.
Bye.
Bye.
Hello. How are you today?
Good, and you?
Me too. Where is Mariana?
I don't know. I call her too.
Não é suposto me ligarem? Ai, estávamos a ligar. Eu pensava que chegava uma e depois chegava a outra. Ah, tá bem. Vá.
Okay, again.
Então vá, again.
Hello.
Hi.
Hello. Yeah. How are you today?
Good, and you?
Me too.
I'm fine.
Só uma pergunta. Só uma pergunta. Como é que alguém disse isto?
Sim.
Alguém estava a ter a barriga, a sério.